Okay, well, now we're going to transition into our next featured talk, which is on youth access to abortion in a post-Dobbs landscape. This is a recorded featured talk, and then Rebecca is going to join us for Q&A afterwards. So get that queued up for you all.
Hi, everyone. Thank you so much for joining us today. We're going to be talking to you about reproductive access around the country for adolescents. Just a little bit about If, When, How, Lawyering for Reproductive Justice. If this is your first time hearing of us, our mission statement is that we transform the law and policy landscape through advocacy, support, and organizing, so all people have the power to determine if, when, and how to define, create, and sustain families with dignity and to actualize sexual and reproductive well-being on their own terms.
My name is Kylee Sunderlin. I use she, her pronouns. I am here with Rebecca Wang, who you just heard from. Rebecca uses she, her pronouns also, and we're really excited to be giving this presentation. Sorry that we can't both be here in person today, but Rebecca will be here to answer questions based on whatever you're thinking about after this presentation. We just want to give you a really quick roadmap of what we're going to be talking about. So first, we'll be discussing what abortion access in the United States looks like now, and then specifically, what does it look like for people who are legal minors? We're also going to do an overview of forced parental involvement laws and how we got here in the first place. We're going to share a little bit about what judicial bypass or judicial waiver hearings are and what they look like and what judges consider. We'll be discussing past and current barriers to access for young folks. We're also going to be discussing future barriers. And lastly, we want to leave on a positive note. What can we do about it?
Right, and then as Kylee said, I will be back on at the very end live to answer any questions and answers you might have for us. So just to give us some grounding and to acknowledge this moment that we're all working within, just last year in June, the U.S. Supreme Court overturned Roe versus Wade. After the decision, laws around the country changed rapidly and continue to change rapidly due to shifts in lawsuits, legislation, and voter ballot initiatives. Currently, some states protect the right to abortion care, while others severely restrict or ban care entirely.
And so here we are. This is a map of, where abortion access even exists. But because, like Rebecca said, the laws are constantly changing, even this map is a bit outdated. And we created it just a couple of weeks ago. So now North Dakota has an abortion ban in place. Arizona has abortion access up through 15 weeks. And honestly, things could shift by the time you see this tomorrow. So just recognizing that, we're doing our best to constantly stay up to date. But if you see this, just, give us a little bit of grace that it might not be perfect right now. But, just to kind of explain how we got to this map, several states right after Roe was overturned enacted trigger laws banning abortion during the 2 months following the Dobbs decision. Many other states explicitly restrict access to medication abortion. A few states have a law banning the mailing of abortion pills, and the vast majority of states have laws containing criminal penalties for violating abortion laws. Most penalties target abortion providers, but certainly not only abortion providers. And we're seeing that change more and more as we're seeing laws targeting and creating new types of criminalization for different populations. But not everything is all bad. A lot of states have also codified a right to abortion under state statutory law and constitutional law. Just shout out to Michigan right now. Others have broadened abortion provider eligibility. 7 states require health healthcare insurers to provide coverage for abortion care, and 7 states have also strengthened data privacy protections related to abortion care.
And beyond access generally, young people also have numerous additional barriers to being able to access care. And that is what the map on this slide represents. Throughout the country, there are states that either require an adolescent to get the consent of or have their parents notified about their decision to have an abortion. Sometimes they're required to do both, get consent and to notify. Or as an alternative, the young person can go to court to request what's called a judicial waiver or a judicial bypass. So first, I want to talk a little bit about what does consent mean, what does notice mean. So some states require notification, some require consent, some require both, some require neither. And here's the quick map to show you what the landscape currently looks like. In the states where abortion access still exists, meaning that abortion access is both legal in that state and that there are actually clinics still providing it, 22 states currently require parental involvement in a young person's decision to have an abortion. 11 of those states require parental consent, meaning that usually the young person has to have a parent or legal guardian come with them into the clinic to sign a consent form. Usually the parent or guardian has to present ID, sometimes a birth certificate showing that they are the parent, or any paperwork that confirms them as the legal guardian. Of course, that comes with its own share of barriers, whether that parent or legal guardian is available, whether they are willing to consent. Even if they are willing to consent, are they able to find the time to come into the clinic, get a document notarized, provide all the legal documents, etc. 7 states require parental notification. This is usually a requirement placed on the abortion provider to try and provide actual notice to the parent or legal guardian, usually some period of time before they can actually provide the abortion. 4 states currently require both consent and notification. And so now, what is judicial bypass or judicial waiver? This existed long before the Dobbs decision, but as you can imagine, it's significantly worse after Dobbs. What a judicial bypass or waiver is the legal process by which a young person can go to court, go in front of a judge, and essentially ask the judge for permission to get an abortion without having to involve a parent or legal guardian. And we're going to get a little bit more into judicial bypass waiver by explaining the law, how these laws came to be, and then we'll transition into what the current landscape for access looks like after Dobbs. Just want to stress here that for young people, whether the route is that they have to get a parent's permission, or if they have to notify a parent, or if they have to go to court to get around any of those requirements, all of those routes are fundamentally bad for young people. Incredibly onerous barriers. Young people deserve full autonomy. They deserve to make decisions about their bodies without having to go to an authority figure, an adult that has somehow been vested with the power to make that decision for them.
So you've already learned a little bit about the national landscape of judicial bypass and like Roe and the legal standard that it said, but just to talk a little bit more about the decision that created this distinction between the judicial waiver process and parental consent and enforced parental involvement. There's a case called Bellotti v. Baird. So in this case, the Supreme Court ruled that if a state is going to require a legal minor to get parental consent in order to have an abortion, then that state also has to have the independent option for that legal minor to prove that they're either mature enough to get the abortion or that it would be in their best interest to do so. And what the Supreme Court said in this decision is that, this is a compromise between traditional legal deference to parental authority over important decisions about their families, about their children, and also that people have the right to choose. People have the right to choose an abortion, that should accompany the right to carry a pregnancy to term, and that is regardless of the age of the pregnant person. And so again, this was just a decision trying to compromise different judicial principles. And so this specific case ultimately upheld parental involvement laws while also establishing standards for the judicial waiver process. This was really this is a solution for the court to give an alternative to giving a parent like a complete veto power over a legal minor's ability to access abortion care. So first, the United States Constitution forbids a person from exerting veto power over another person's decision to have an abortion. Secondly, parental consent laws must include an alternative mechanism to abortion access. Third, the alternative procedure must provide an effective opportunity for the abortion to be obtained. The alternative procedure must be independent of parental involvement, and the alternative procedure must be confidential and expedited.
So now we want to spend some time walking through what the judicial process actually looks like. Here's what the law generally requires judges to consider. 1, is this young person mature enough to make this decision without telling their parents or asking their parents for permission? And is not telling their parents or asking for their parents' consent in the best interest of the young person? And it's also important to note here that in at least one state, the best interest standard is actually whether getting an abortion is in the young person's best interest, not whether telling their parents is in their best interest, which is what the standard is in a vast majority of states. The judge can make their decision based on either inquiry. Both can certainly be true, but a judge is only required to find that one exists in order to grant a bypass. Maturity factors generally include prior work experience, experience living away from the home, whether they handle their own personal finances, how well somebody is doing in school, and if they aspire to continue their education. I think you'd be really hard-pressed to find a judge who doesn't want to hear whether the person requesting the bypass fully understands and has considered each option available to them. So whether they've considered abortion, whether they've considered carrying the pregnancy to term, whether they've considered adoption. And a lot of judges also want to hear that the young person understands the possible consequences of each of those options and why they landed on abortion as the best route for them. Many judges ask if they use birth control, and if not, why not? Those same judges frequently ask if the person intends to now get on birth control in order to avoid another unwanted pregnancy. And since the young person is in front of the judge because they cannot or do not want to share their pregnancy with their parents, a lot of judges also want to know if this young person has any supportive adults in their life who they discuss their pregnancy with. Now, this list is certainly not exhaustive, but these are the types of factors judges consider in their maturity analysis. For the best interest analysis, the factors that judges consider generally include the young person's emotional or physical needs, the possibility of intimidation, either from their parents or from the other person involved in the pregnancy, other emotional injury, physical danger to the young person, again, either from their parents or from the other person involved in their pregnancy, stability of their home, and the possibility that consent would never be a viable option or that notification would cause serious and lasting harm to the family structure. Most judges want to hear about the relationship between the parents and the young person and the effect of notification or consent on that relationship, including the possibility that notification or consent could lead the parents to withdraw emotional or financial support.
And so this is Kylee speaking, and one of the things that I do in my role is I represent legal minors in judicial waiver proceedings in Michigan. And so I just want to take a step back and talk about, based on the folks I've represented, what I've seen, what people have been kind enough to share with me, some of the roadblocks, and just want to share one story, which I will say I am using entirely different initials for this person, and I've changed 2 important details to ensure their anonymity. But what we're talking about today is about people facing really extraordinary obstacles to accessing abortion care, and how this is especially true for legal minors. This continues to be true in the state of Michigan, where, as Rebecca explained, people are either forced to get the consent of a parent or the consent of a judge. These are really onerous legal requirements that force people into a legal system. And sometimes this happens even when people have the support of a parent or a guardian. And so one person I'm thinking about specifically, I'm going to refer to her as AC. She was a 17-year-old who contacted me, and she was in deep distress. Her mother had died. She was estranged from her father. And even though she had the unwavering support of a family member who was also her legal guardian, the family member only had a temporary order of guardianship. The final order hadn't been issued by the court due to COVID-related delays, and the clinic couldn't accept the temporary order as legally sufficient documentation of guardianship. So in this scenario, this person had endured the trauma of losing one parent to death, didn't have a relationship with the other, and here she was calling me, doing what she had to do in order to access the very basic healthcare that she needed. And so after speaking with me and scheduling a hearing, she then had to explain to a judge, a complete stranger, why she didn't have a parent who could consent on her behalf. And during that hearing, even before that hearing, in my conversations with her, and her strength and composure really bowled me over. But she was not the exception to the rule. Not for me, and not for anyone I know who represents people in these hearings. Like, that is really the rule. What we know is that an overwhelming majority of young people voluntarily involve at least one parent in their decision-making process. And so when they don't, people's reasons for not doing that are always incredibly compelling. Most often the reason that they don't include, a fear of conflict or escalated conflict, the belief that sharing information would significantly damage their relationship with their parent, and oftentimes the desire to protect a vulnerable parent. And so just because someone didn't involve a parent doesn't mean that they didn't involve their families or another supportive adult. And this is what I want to stress. Every single person I have represented in judicial waiver hearings has discussed their pregnancy with and relied on a supportive adult in their life. Those adults have ranged from older siblings to aunts to grandparents and teachers and mentors. It also includes parents or legal guardians who supported their decision, but like the example I gave, they lacked the legal documentation required to give consent. And even though every person's reason for seeking a bypass is different, the one constant is that no one is making this decision alone. And the sentiment that young people make this decision deliberately and in consultation with people they love and trust has been reinforced with every single young person I've represented. I am consistently impressed by their candor and maturity and thoughtfulness, and just, what determination and resourcefulness it requires to be able to navigate this daunting process and able to access healthcare. And so, I just want to end by saying, some of the barriers that people are accessing, it's not just consent or waiver. It's, facing the possibility of petitioning a judge that is hostile to abortion, trying to protect their privacy and safety while also having to leave school or home or work to get to at least 3 appointments, 2 at a clinic, 1 at a court, arranging transportation to and from court and the clinic, finding the funding to pay for their care. Just that, having to navigate this feels daunting for me. I am a 39-year-old lawyer who helps people navigate this. And when I think about doing it on my own, it feels overwhelming. And so just want to say that, like, to the extent that anyone in this room is engaged with young folks who are navigating this process, please keep in mind the extraordinary amount of hoops that they are jumping through and the additional stress and weight that they have to endure, that's both unnecessary and actively harmful, and ways that we, as people interacting with them, either in the provision of healthcare or other supportive services, ways that we can help ameliorate that. We're going to get to that later, but just, I think always considering like the enormous barriers that are in place, particularly for young folks when accessing abortion care.
Thank you, Kylee. And while we're spending a lot of time today highlighting just how large of a barrier parental involvement laws are and judicial bypass is, certainly that is not the only barrier facing a lot of abortion seekers, but also young people seeking abortion specifically. Just recognizing this current landscape, the post-Dobbs landscape, a lot of clinics are closed or they have moved out of state to continue providing services in a state where it is still legal for them to do so. And even in those states, a lot of clinics have reduced the services that they offer, or are especially hesitant to work with young people, and so are turning people away. Really, again, out of an abundance of caution, we understand in this very confusing legal landscape, but that certainly is a barrier to young people seeking services. Of course, there are all the things that were in place even before Dobbs, things like waiting periods. If young people are able to travel, if they are able to get transportation, ending up someplace where they have to wait 24, 48, 72 hours between their initial intake appointment before they can actually get an abortion. That's time away from their life. That's time away from their work, their school, their other responsibilities. Of course, there are clinics that are required by the state that they're in to provide mandatory counseling, which can oftentimes be incredibly biased and present really harmful and scary information about abortion that really coerces young people into not going through with the abortion care that they want. Of course, there are overarching barriers, just the cost of the procedure, whether they are able to get insurance coverage, whether that insurance coverage is potentially through a parent or a guardian, what potential additional barriers that might represent. And of course, oftentimes, the information that young people are accessing online, when they Google abortion or abortion clinic near me, a lot of times the information, the websites they're getting on are those that belong to what we call crisis pregnancy centers. So CPCs are often organizations that are religiously sponsored, that provide no actual medical care, are not run by any medical professionals. And again, their intention is to provide inaccurate and harmful information to people seeking abortion in an attempt to talk them out of seeking the care that they want, or to shame them out of the care that they want, etc. And of course, just in general, the potential that a young person has to go to court is incredibly intimidating for any of us, but particularly if you're a young person, particularly if you're in the incredibly vulnerable place of asking to get an abortion, because you are not allowed to, because the state tells you that you are not allowed to make those decisions for yourself and about your own body. And at this point, you might be asking yourself if it can get any worse. And the answer is that yes, it can, and it is. Again, we've talked a lot about shifting landscapes, about new legislation, new barriers that are always coming up. And so some of you might be aware that very recently, just last month in Idaho, the state passed what it's calling its Abortion Trafficking Act. Since abortion is prohibited in Idaho, what the bill does is it makes it essentially illegal for an adult to help a young person leave the state to seek abortion care, even if they are going to a state where abortion care is legal. It threatens the adult that is transporting that young person with anywhere from 2 to 5 years in prison. And even though there's a lot of talk about how it's to, protect parent-child relationships and prevent bad actors who are adults from being part of that, parents' permission for that young person leaving the state does not protect the adult that is transporting them from being charged and being prosecuted. It can only be used as a defense after the fact. And as you can all imagine, just being charged as being prosecuted is incredibly intimidating. It is a risk that many adults will not want to take on. So what this means is, even if there is a trusted adult that a young person is able to turn to, that young person may not ask because they don't want to put that adult at risk. Or even if they do ask, the adult may be very hesitant to offer any help out of a desire to avoid being criminalized themselves. So really creating a situation where young people don't have a trusted adult to turn to at all, which plays into this atmosphere of fear that a lot of this legislation is creating. Even in states where abortion access is available, where there is assistance available to young people, oftentimes people are afraid to ask about abortion, to search for information, to ask for advice, to ask for help. And that really is, I think, the true intention behind a lot of this legislation is just to create that fear that dissuades somebody from getting the care that they want. And of course, beyond just fear, the risk of criminalization is very real. And anytime there is new law that punishes people seeking abortions, people assisting people seeking abortions, it definitely widens the net for who could potentially be criminalized for just seeking abortion care.
Okay, so now I am going to talk about what you can do about it. So as people who are working with adolescents, I think that there are some guiding principles that can help reduce harm and also increase support. So, one of the things that we are consistently hearing from young folks is that some clinics are just turning them away. So during the judicial waiver process, judges frequently want to hear from young folks about that they've confirmed their pregnancy at a clinic, that the clinic dated their pregnancy, that they spoke with a healthcare provider about their different options, that they really clearly understand the implications of their decision, whether it will be a procedural abortion or a medication abortion. And what's incredibly disheartening and yet another barrier for young people is when clinics say, we can't schedule even an initial appointment with you until you get a bypass. And so they're in this horrible predicament where in order to get a waiver, they need to be able to testify about this first appointment. And in order to get this first appointment, they need to have the waiver. And so if you work at a clinic, if you know someone who works at a clinic, please, there is absolutely no law that in any way requires you to have an order in order to be able to provide pregnancy confirmation or dating to anyone based on their age. You don't have to bill insurance for it. People can pay for it out of pocket. Not only is there not a law, but it is important. It is critical that we give adolescents access to this care, not just if they're seeking the judicial waiver, but people need to have information about their bodies in order to be able to figure out what course of action is best for them. If someone can't date their pregnancy, then how do we expect them to make an informed decision? So the first thing I want to do, again, is just implore you that if you are in any way working with a clinic or know folks who work at clinics, please, this is a really important barrier that we can help break down. So that's the first thing. The second thing is, I want to talk a little, Rebecca she touched on criminalization. And I want to just talk a little bit about privacy. And, as we are thinking about digital security and privacy and confidentiality, the confidentiality of these judicial waiver hearings, I'm always thinking about what can happen. Like in Idaho and the law that they enacted, how is this going to potentially expand, and what are things that we can do to try to protect ourselves in advance? And so if you are someone who's providing care to someone, and part of that care includes charting, medical charting, or anything else, I want you to always be thinking about whether it's clinically significant to the care that you're providing to the patient in that moment. And so if someone discloses to you, maybe that they've self-managed an abortion previously, or that they did have a previous abortion, is that clinically important to the care that you're providing to chart something that could potentially be used against someone in the future? So for example, do you really need to chart whether someone had a spontaneous miscarriage or acted with intent to cause a miscarriage? And then similarly for medical records, what does the next provider caring for that patient need to know? And I'm saying this so that we can all approach it with the understanding that medical records can be, and almost always are, subpoenaed. And so, just thinking about that as a baseline can help guide you in the moment on the question of what is clinically significant. Another thing I want to touch on is mandated reporting more broadly. So while there are some exceptions, reporting is often incredibly subjective. It is up to you as a provider, as a mandated reporter, to decide if you think that a report is warranted under the law. And so this is true around if someone reports a self-managed abortion. This is true if someone reports that they're experiencing intimate partner violence. This is true if someone reports something that you may perceive as abuse or neglect by a parent. And so while I think that there's a lot of really incredible work being done around challenging what we've been traditionally told about mandated reporting, here are some concrete things that you can do. So what kind of anti-bias exercises might you take yourself through to either confirm or deny a suspicion that you need to report something? Many of you likely already know this, but in particular, what you say to your patients or clients or young folks about your reporting obligations can be protective for them. And so everyone deserves to have the opportunity to consent to a report. And so you letting them know that if they say certain things that you'll be obligated to report is a way to help that consent happen. So I just want to give you a scenario. Let's say that you are working at a clinic with a young person who you've confirmed and dated a pregnancy for, and they disclose to you that they need to access abortion care and that they need more information about the judicial waiver process because they feel quite certain that if one of their parents found out that they accessed abortion, that they would face physical or emotional abuse. And then they share some emotional abuse that they've experienced from that parent. It is incredibly important as providers to be able to tell people that sharing information about that could result in really violent and traumatizing state intervention to their family, right? Because that could really dictate what your patient shares with you. Just because someone doesn't feel comfortable sharing this decision with a family doesn't mean that they want the state to remove them from their parents' home. And so putting the power back into the people who are disclosing their lived experiences with us is an important thing to keep in mind. I also know that sharing this with patients means that they might not tell you everything. And I know that that can feel really frustrating as providers because you just want to provide the very best care that you can. But when you think about the people and the care you're providing, like, we have to trust that people know about their own lives and can make their own decisions about how and when they might want to involve the authorities in something. Like, people are the best decision makers. They are the most knowledgeable about their own lives. We are not. And so I just want to encourage everyone to trust your patients. And then lastly, I want to say that it's also important to understand the difference in the law between something that is a must report and a may report. A may report means that the law doesn't require it at all. A provider could just choose to do it anyway. And for a law that says a provider must report, you still have the discretion and power not to do it. Because again, reporting is so subjective. It is the provider's experience of abuse or neglect that tells them whether or not the law requires them to report. And we know that it isn't fair that the law enforcement deputizes people in this way to surveil your patients or your clients or people you're just trying to give care and support to. But I encourage you to ally yourselves with other folks who share your values so that you can be support systems for each other around reporting systems.
And we recognize that was a lot of information, and I want to end on the note that you're not alone in this. And neither are young people alone in this. If you know them, if you care about them and you want to know where to send them, there's 2 routes through which you can reach us. I offer technical assistance. The link for that form is available there, but I can also make sure that the organizers of the conference have that available to you separately. But if you just have a question about what the law is in your state, if you are supporting a young person and just don't know under what circumstances you might be required to report, please reach out for technical assistance. If we can't answer your question, we will help you get in touch with somebody who can. And then on the other end, if a young person you know has a question about how the law may impact them where they are, what their options may be, they can contact our main helpline at Repro Legal Helpline, and our website is there as well. We have both a phone line that they can leave us a voicemail on, as well as an online form they can fill out, and we can offer support in really any language that they need. So please, don't hesitate to get in touch with us and send people our way.
Okay. Thank you so much, Rebecca, and to Kylee, who couldn't join us for the Q&A. Getting my screens correct again. Rebecca, thank you so much for being here. And I'm gonna see if there's any questions that are coming up in the chat. Okay, so here's the first one. They say, interesting, important information, thank you. How long does the process of getting a waiver take?
Yeah, thank you for your question. So it varies depending on the state. Generally, every state statute says that the process should happen with as much speed as possible for consideration for the young person. So usually the first step in the process is once a young person has confirmed their pregnancy, they have to file a petition in the court in the right county. Usually within 24 hours of them filing that initial petition, the judge is supposed to schedule a hearing. About 24 hours after that hearing, the judge is generally required to make a decision either way, either that the waiver is granted or that it has been denied, to give the young person an opportunity to appeal. Depending on the state, sometimes the requirement is not 24 hours. Sometimes they have up to 3 days, et cetera. But of course, any kind of delay when a young person is trying to get an abortion is of concern, especially if a young person is denied. That kind of decision of, do I now appeal back in this court? Do I need to make arrangements to leave my state? Is my only option now to get parent consent or notification? That all adds to that timeline, but it does vary. But generally within a week, that decision is supposed to come down.
Okay, thank you. Let's see if there's any other questions. Just a couple comments. Thank you so much. Thank you for helping us navigate these tumultuous times. The next question is mandated reporting the same across the country?
Thank you for that question. No, it's actually a very confusing landscape of laws. Who is actually considered a mandatory reporter, under what circumstances, varies from state to state. What the actual reporting requirement is varies from state to state. The amount of discretion a medical provider has, kind of that distinction Kylee made about, must report versus may report, varies. And we also know, even just, from hospital or clinic to hospital or clinic, there are some hospital policies that are more conservative than what the state actually requires. So that all varies. And we definitely understand why that's a very confusing landscape for a lot of folks to navigate.
Mm-hmm. Yeah, I have a social work background, and just even how different professions talk about and view mandated reporting, I find to be pretty varied as well. So yeah, thank you. Right. Next question, does the state appoint representation for making the request with the courts?
Yes, generally, anywhere there is a judicial bypass process, the court is required to provide an attorney free of charge to the young person. The kind of difficulty we have with that is who the attorney is that gets appointed can part of be like a longstanding roster of general practice attorneys that take cases on for the court. What we have found through various reports is whether you get an attorney that has taken on a judicial bypass before is completely unknowable to the young person. We've had young people trying to call their appointed attorney for like days at a time and not get a response because the attorney didn't know that they were supposed to take this case, or the attorney had no expertise in the case and wanted to kind of like sideline. There are also, unfortunately, we've heard cases of attorneys who are very unfriendly to young people seeking abortion, who themselves are giving very biased counseling. Shaming the young person is something that does occasionally happen. So, part of our work at If When How is meeting with more attorneys, training them, not just in the technical, how do you take a JB case, but just in the broader, what does it mean to humanely treat a young person in this situation? How do you center their decision-making and their autonomy? How to put your personal biases aside or investigate your personal biases so that you're not negatively impacting the young person. So yes, long answer, an attorney is generally available. Whether that young person actually gets good legal support is, it depends.
Yeah, thank you for that. And the work that you all do in terms of training other lawyers, that's so much of what we do at AHI, is trying to help other professionals be more adolescent centered in the health space. But it's so heartening, I guess, to hear that y'all are doing that in the legal space as well. So we thank you for your work in that. A question that may or may not be one that you can answer, but I'm going to ask it just in case. Sure. The person says that they work for a federally qualified health center, and they struggle with Title X and HRSA requirements. Any advice on towing that line?
Yeah, similarly. Was there another part of the? Yeah, I'm not an expertise in Title 10 requirements. So I will say generally, there may be some wiggle room for you, especially as far as, the advice that Kylee provided about the amount of discretion you may have in determining what is worth charting and what is not worth charting. And of course, providing that kind of information of just so you know, if you mention these topics in these ways, I may have to report. Right? Like that kind of stuff is all generally going to be okay, regardless of whether Title 10 requirements may apply. But if you have like a more specific question and you don't want to ask it here, please get in contact with me through our TA form and we can talk more about it.
Yeah, that's such a great resource. And I'll put that in the chat again later. Another question, how can organizations and individuals attending here today support your work in serving adolescents?
Yeah, I think in the very real way, just like attending the session and hearing us out and recognizing some of the experiences that young people are navigating right now, I think is great. I think it helps, having that as a toolbox that you bring with you into your practice, and considering the whole circumstances that impact a young person. I think I can't stress enough that's so important in our work is that you do your work, and that we work hand in hand to support young people in this. But yeah, we often have kind of policy asks for providers in various states. We often ask providers to kind of challenge the parental involvement laws in the state where they are. Of course, we highlight judicial bypass as the big barrier. But of course, a lot of people say it's better to have judicial bypass than to not have it at all, which is true. But if we could completely wipe away parental involvement laws from the books and young people never have to go through that process, that is what we're aiming for. So on the policy end, if your state has a parental involvement law and you want to know, how you can get involved in policy work to get rid of it, yeah, please reach out to me. We would love to kind of see how we can collaborate on that.
Great. Do you all have a newsletter or social media so we can follow your work in that way and stay up to date?
Yeah, I think we are on all the social media as If When How. We do have a newsletter. If you visit our main website, ifwhenhow.org, you can get signed up and, stay up to date with all the work that we're doing.
Great. Okay, next question. Can we send clients to consult an attorney? Would I be breaking the law by providing attorney information? And where would our client get the information on where to go?
Yeah, there are probably specific instances where this is not going to be true, but on very general end, kind of saying to a young person, oh, this seems like this may be a legal issue that you may want to consult an attorney about is going to be okay. That's not you offering any legal advice. That's not you telling the young person to take a particular course of action. What it might mean for you to actually provide an attorney referral could be a little bit more complicated. So again, if that's, kind of a situation you see yourself in or have experienced and want to know next steps, please reach out to me via the TA form so we can chat more about it.
Great. This is a Michigan specific question. If you know this one, they say in Michigan, in school-based and school-linked health centers, we cannot refer for abortion services. Mm-hmm. Are there any changes on the horizon?
Unfortunately, I'm not the Michigan expert. Kylee is.
Yeah, Kylee,
she's unable to be here. Not to my knowledge. We're aware that that's an issue, and to my knowledge, there has not been change on that.
Got it.
But I mean, the positive thing is that there is like policy movement in Michigan to remove the parental involvement law. So at least on that end, JB will no longer be a barrier to young people seeking care. And I'm hoping that will help like open the lines of young people being able to better find information.
Yeah, definitely. Thank you. Are there any other questions from the audience? Let's give a few moments to see if any others pop up. You're welcome to ask them in the chat or in the Q&A. Mm-hmm.
And if you think of a question down the line, you know how to get in touch with me. So
yes.
Yeah.
I'll go ahead and put those resources in the attendee hub chat one more time for folks, because it sounds like there might be some folks wanting to reach out to y'all.
Great.
Yeah. Any other questions, audience? Okay. Just some folks saying thank you. Thanks for the information. This is obviously so timely and important. And I know you're traveling today too. Is that right, Rebecca? So thanks for
Yes.
making this happen to be here. We have one little maybe a nice question to end on, I'm thinking, which is how are you staying positive during these tough times?
Ooh, to be fully candid, I want to say it's tough. It feels like we're really on the, spinning the wheel of fortune for what is the bad news today. But I am always heartened everywhere I go. There are always people proactively thinking about how to make abortion easier to access, even if it's just from the point of destigmatizing it among their own family and friends and talking about why it's necessary, especially in regards to young people, which is oftentimes even people who are pro-abortion have kind of squishy feelings when it comes to young people accessing abortion. But I love that people are talking about it more, that we're centering young people's autonomy in this more. And so I am incredibly heartened by that we are considering that young people have unique access barriers. I'm always heartened by the fact that most young people seeking abortion are able to find an adult that they trust to confide in. And then on the long end of it, people have been accessing abortion care for a long, long time, regardless of what the law has said about it. And people continue to do that in very supported ways, which we're not going to see on the nightly news, but I know it's happening. So overall, I'm heartened that there are so many people proactively providing information and resources to their community during this time.
Yeah, absolutely. And I love what you said about young people being able to usually find a supportive adult. And I think as folks who work in healthcare, we can be those people for them.
Absolutely.
So I always really take that away.
Mhm.
All right. Well, I don't think we have any other questions. Again, thank you. And thanks to Kylee for this wonderful presentation. It was a great way to sort of nearly wrap up the day. I know we have a networking session coming up right after this, but thank you, Rebecca. We appreciate you.
Yeah, thank you and have a good day.
Thanks.